Hi there, Philip Kirk in Nashville. In my introductory video, I mentioned that we would talk about how to know what to believe, and this is it. Now I know this is not the sexiest subject on YouTube, but I think you'll find it very interesting because it is an inside look as to how a part of the legal system works. As you well know, from the time you wake up in the morning until the time you go to sleep, you are bombarded with countless messages and information. And while you don't realize it at the time, you are making a mostly subconscious decision as to which of that information to believe. Right now, I want to talk about some tricks or methods to use in deciding what is real and not real, and this draws upon principles found in the legal profession. The principles, sometimes called instructions, are used in thousands of decisions that are made every day in courtrooms across the United States, and I'm going to dwell on 4 of them today. But before we get to these 4 principles, I'm going to talk about something I hear quite often, and that is when people talk about the fact that evidence is not good because it's circumstantial evidence. There are basically 2 types of evidence. One is called direct, and the other is called circumstantial evidence. And if you think for one moment that circumstantial evidence is not that important, I'm here to tell you that there are many thousands of people sitting in prison today because they were convicted using circumstantial evidence. It is just as important as direct evidence. Now just quickly, direct evidence is direct proof of a fact, such as testimony from a witness of what the witness personally observed. For example, a witness could testify that I saw it raining outside. That would be direct proof that it's raining. Another witness, however, that was inside could say, it was raining outside because I saw someone enter the room carrying a wet umbrella. The law allows you to give as much weight to circumstantial evidence as direct evidence. Now I want to go to the board and talk to you about those 4 legal principles. The first one of these legal principles is falsus in uno, falsus in omnibus. In other words, false in one thing, false in all things. And this is my overall favorite. I have relied on this so many times to win court cases I can't count them all. And of course this is Latin. And we lawyers like to use Latin because it's the language of our club. And although I took 4 years of Latin, I have yet to have a conversation with anyone in Latin. Anyway, what this means is if a witness is testifying and they testify falsely as to some relevant fact, and it has to be a material fact, it can't be like something like it was warm outside when another person says it was cool outside. That's so subjective that it doesn't count. But a relevant and material fact is one that is important to decide in the case. And so this principle says that if you find that a witness has testified intentionally falsely, in other words, lied about a material fact, that you can disregard their entire testimony. In other words, everything that they might have said during their 5 minutes or 5 hours of testimony, and which it may have been quite compelling. But if they've intentionally lied about some relevant fact, then you can disregard all of their testimony. And why is this my favorite? Because in countless trials I have had, there's what we call direct examination and then cross-examination. In other words, when I'm representing a plaintiff, for instance, and the other side puts on the defendant testifies as to why the plaintiff is wrong or incorrect, I then get a chance to cross-examine that defendant. In other words, defendant's attorney has called the defendant and asked him a bunch of questions. I then get a chance to get up and try to poke holes in that testimony. If I'm able to show in some relevant factor that they have lied in their earlier testimony, I have often watched the expression of judges turn from day to night, juries also. And then the testimony they just gave becomes useless because they have lost the case. That's how important that principle is. The second principle is impossibility of performance. And you see this mostly in civil rather than criminal cases, but it can apply to many situations. If a witness testifies that this happened a certain way, and you get up and you have gone out in advance and say, calculate the mileage between points A and B, and this witness testifies that, well, at such and such date, at such and such time, I left and I arrived at B at a particular time. And if you've done your homework in advance, you know exactly the mileage between A and B. And if you can show that it was impossible for this person to get from A to B in that amount of time, then it's impossible for his testimony to be true. And you win the day. There are an unlimited amount of situations that this can amount to, of course. But for instance, can an office fire in a small portion of 3 floors bring down a 47-story skyscraper in its own footprint? Can a person who has difficulty flying a Cessna airplane fly a 767 jet? Something to think about. Okay, the third one we're going to talk about is intervening cause. I'm going to use an airline example here as well. Let's say an airplane is flying at 35,000 feet and all of a sudden loses altitude and crashes. Okay, the obvious speculation is that, well, the airplane malfunctioned, or the pilot dozed off and slammed into the ground. But upon closer examination and testing, you find evidence that a bomb went off. Of course, that is the intervening cause, and therefore there is not negligence on the part of the airline, and it's not negligence on the pilot that caused the crash. It was their intervening cause of the bomb going off that caused the crash. Now the last one you've all heard of, mostly in the realm of criminal. You've probably seen this on TV and in many trials, and that is motive. Now, if I can remember, the definition of motive is that which moves the will and induces action. Sounds straight out of the 1700s, I know. This principle simply means that people universally have a reason for doing something before doing it. So there you have it. These are some guidelines you can use to determine if the facts and stories you're being told are true or not. And keep in mind that it's just as important, maybe more so, that when you are confronted with facts and stories, that you get off the fence and make the decision as to what to believe. Thanks for watching. I hope we can visit again. Until then, over and out.